The member for Fox Hill for the wrap-up. You recognize.
Yeah, thank you, Mr. Speaker. Just a few points in answer to the certain observations made about the sections of the bill. To deal with the member for Montague's comment with regard to Clause 14 of the bill, Clause 13 of the bill, with regard to the new Section 30A and the grant of a resident belonging permit in the case of someone born in the Bahamas to non-Bahamian parents who is entitled to apply for registration as a citizen of the Bahamas under Article 7 of the Constitution and is residing permanently in the Bahamas at the time the application is made. The member raised the question of the constitutionality of this provision. Well, we'll certainly have the lawyers check it, but I don't see that it, that on the face of it, that it offends the Constitution at all, unless I've missed something. Excuse me. What the section was meant to deal with, or the mischief that is intended to be cured with this, is a situation where the Constitution gave someone the right to apply for citizenship of the Bahamas between the 18th and 19th birthday, but it conferred no immigration status on that individual. And this bill is simply, this provision is simply designed to provide an immigration status, or to have the ability to provide an immigration status for someone who finds themselves in that position. Now, I take the point that what you're saying is that people who have left the country and come back will fall outside the ambit of this. But I would suggest that that would be the minority of cases. The mischief that this is designed to cure is people who have lived here all of their lives and have no status. And that's the real big category you're trying to solve. With regard to those people who fall outside that category and have gone away and come back, two things as a matter of practicality happen. One is that you're right, the application is still considered, but there are ample provisions in the Immigration Act itself to provide some other status for an individual who falls into that position, either a general worker permit or a specific work permit or a residence permit, or of course the granting of citizenship or permanent residence with the right to work. All of those things are available. But this status is really just designed for people who are here all their lives. So it's specifically geared at those persons, and it does not strip anyone of their entitlement to apply at their birthday. It's merely designed to give an immigration status to that individual. Because people have been under the misapprehension prior to this that because they get a certificate of identity, that this certificate of identity actually gives them a status. And part of the confusion has been furthered by the fact that the U.S. authorities accept, or have accepted in the past, the identity document as a document that they use to travel and get visas. In fact, the identity document should only be used as an emergency passport. Where you don't have a passport, you have to travel immediately and you need the passport, or they're now issued in the circumstances where I think Ghanaians have to actually travel to Ghana to get a passport, and so if you're a baby born here and you've never been to Ghana before, the Bahamas government will issue you a certificate of identity, which is a one-time use document, so that you can go to Ghana and get the passport of your nationality. So those are some of the, we have under our international obligations to do that. Now, the other category that was mentioned by a previous member, Palm, was the second generation people who have Haitian ancestry. And the question is whether they are in fact stateless. This is a matter which we're referring to the Haitian government. My preliminary chat with them is that that is not the case, that once their parents have gotten the citizenship, then they can also get the citizenship. But if that's not the case, we have indicated that where someone is actually stateless, we accept we have an international obligation to provide at the very minimum an identity document, and then secondarily some form of legal status of residence until the statelessness is resolved. And that we will follow that obligation. So that, I just wanted to explain that that's the mischief we were seeking to cure and we think that we've done so without offending the Constitution. The Member of Parliament for Tall Pines spoke with regard to the provisions on the permanent residence, the right for permanent residence for spouses who were divorced or surviving spouses, and also the spousal permit. I believe he was referring first to Clause 12 of the bill, which says that Section 30 of the Principal Act is amended in subsection 3 by the insertion immediately after the word occupation of the words provided that such permit shall, where there are children of the marriage, remain valid so to its expiration date, notwithstanding the death of the Bahamian spouse or a decree of divorce of a competent court or a deed of separation from the Bahamian spouse. And then secondly, where applicable, be extended for such further period as may be required pending the processing of an application for any other status. And B, where there are no children of the marriage, remain valid to its expiration date, notwithstanding the death of the Bahamian spouse or decree of divorce or of a competent court or deed of separation from the Bahamian spouse. The mischief here is that spouses found themselves in a situation where the spouse died, either husband or wife died, and upon the death, you had no status in the country. And that essentially meant that immigration could turn up on your doorstep and say, out you go. So they wanted to provide some status, first for people who had children in the marriage, date of its expiry, so you didn't lose the status. Similarly, in the case of a divorce or separation. And I know that this is a very emotive subject, but we have had a number of cases which came to our attention where, and this is mainly women, have been in abusive relationships and they have to get out of the relationship. They're children of the marriage, and that means once you're separated, the status expires. So this is meant to try and deal with people who find themselves in that situation. It's slightly different for those where there are no children of the marriage. It simply says that when the spousal permit expires, it expires, but it does not cause you to lose your status immediately upon losing the marriage or upon death. So it provides some status there. So that was the idea with that one in Clause 12 of the bill. And then in Clause 10 of the bill, which amends Section 19. Oh, sorry. No, that's the wrong one. Sorry, it's Clause 8 of the bill, where you can apply for a certificate of permanent residence by a divorced spouse or a spouse living apart from a Bahamian citizen. And again, the mischief that they're trying to cure here is, or to provide for, is a situation where you have lost the marriage, you may be in an abusive relationship, and just to be able to provide some status for the individual, and to go up a bit further, if you go to Clause 7, to provide where someone is married and there's a surviving spouse of a citizen of the Bahamas, that again you can still have the status of permanent residence. And sorry, Clause 8 is designed to deal with the fact of if you are a former spouse, you can also get permanent residence with the right to work. So that's the mischief that we were trying to cure. I'm sure as it goes along, you'll probably have to tweak this some more because you always find new things. But as I said, it's an amending and reforming statute. With regard to the processing of applications for citizenship, both citizenship and permanent residence with the right to work are matters which are decided by the Cabinet. That requires, if you know Cabinet time, those of you on the other side who've served in the Cabinet, you know that Cabinet time is precious, very difficult to access. So it is it is dependent upon a number of factors in order for the processing to take place. Of course, there can be more efficiencies with regard to it, but that is the main issue with regard to the processing of these applications. And the Cabinet guards jealously the power to grant citizenship and permanent residence. It's very carefully deliberated upon, and that's the present policy position. We try in the interim to make sure that people have some immigration status so that they are not prejudiced in any way, and try to move the processes on. And I think given particularly the public sensitivities about this in the last few months, that these things are being dealt with every week to try and chip away at what has been described here as a backlog, so that we can get through it and understand that people can have a proper permanent status in the Bahamas. So that's an answer on that point. Generally speaking, then, it appears, Mr. Speaker, that the House supports these measures that have been advanced. We hope that the Bahamian people find them generally acceptable.
Member Foster answered.
Yeah.
I just, the minister is right in terms to be generally accept with the amendments to the bill. But I said in my contribution, clause 17, with the sector and discretionary power, I had a problem with that, right? So I just wanted, if the minister can speak to, I know what the act says and what is the intent. Can he clarify that a bit for me?
Very well. Thank you.
Oh, sorry, about the sector policy.
Member Foster.
Even though the word appears here, the minister may formulate and implement a sector policy detailing the manner of and criteria for the exercise of the minister's discretion under this part, and publish the sector policy referred to in paragraph A of the Gazette in 2 newspapers of general circulation. And this sector policy may be amended from time to time. In fact, this replicates provisions from other acts where the minister has the power. But when the minister, when you say minister, it actually means the cabinet. So it isn't the minister, just determining and signing off on the policy. The decision is in fact made by the cabinet.
Member Yields, Chair recognizes Member Foster.
I just wanted to thank the minister for the clarification. If in that state, I fully support the bill.
Thank you, Honourable Member. Member Foster.
So it appears then that the provisions in the bill are broadly supported by all members of the House present. I appreciate, on behalf of the Department, the support that has been given for these measures. We are acutely aware of the sensitivities about the need to, the balancing act that I talked about, that all policies have to be executed humanely. The opposition spokesman on foreign affairs is aware about his own access to the detention center. I believe that transparency and access is key to ensuring that the detention center is properly run and that it meets objective standards. It is a work in progress, as is much of this. And as I say, we hope to execute our duties and responsibilities on behalf of the Bahamian people with the full knowledge of those sensitivities. So I thank the House for its support, and I look forward to the formal vote, which will then send this bill on to the Senate. So thank you very much, sir.